Right, to this now, and the Supreme Court of Appeals has ruled that the preferential procurement policy framework is invalid. It says applying pre-disqualification criteria for public tenders is unconstitutional. The application was brought by business organization Sakelicha, but the broad-based Black Economic Empowerment Commission says the ruling will have no effect on B-BBEE Act or its requirements. To explain all of this, we are joined now by Econo BEE Director Muriel Mushariwa. Muriel, thank you so much for joining me this afternoon. So what is the significance of this ruling around the preferential procurement framework?
So the significance of this ruling is the fact that before you even get to tender for a specific tender, they basically had a clause in basically a regulation that the minister had given to say that there needed to be a pre-qualification criteria which could be placed at the discretion of whichever organ of state. So the organ of state would have discretion to decide that, okay, before anyone has an opportunity to pitch for that particular tender, they would have to fulfill a pre-qualification criteria. Now, in terms of the Act, the principles of the Act are fairness, equality, and transparency. And so that means everyone should be given an equal opportunity to bid for that tender. And then obviously there would be criteria to that tender. So if the tender is less than 50 million, 10 points would be, rather 20 points would be allocated to BEE compliance, and then 80 points would be allocated to price. And if it's over 50 million, then 10 points would be allocated to BEE, and then 90 points would be allocated to price. So in this particular regulation, the problem was that the minister was allowing the state organ to decide which particular tender would have a pre-qualification criteria. And that obviously would lead to abuse, which the applicants were able to show the Supreme Court of Appeal. I
see. So in the bigger scheme of things then, does this ruling assist the implementation of broad-based Black economic empowerment, or does it hinder the application thereof?
So here it basically hinders any pre-qualification for a tender, but it still means as an entity or a company, if you want to tender for government tenders, you still need to be BEE compliant because you're going to earn points in terms of the system. So I think we need to separate the two. BEE is still applicable. You have to be BEE compliant if you want to do business with government, and in other instances if you want to do business with private entities. But with regards to a pre-qualification, what the court was saying to the minister is we need a framework to avoid abuse, to avoid unfairness or a lack of equality of opportunity. We want to ensure that there's a framework of saying when do you apply this pre-qualification criteria.
And coming as it does at the moment, while issues of broad-based Black economic empowerment are under the spotlight, what we've been hearing coming out of the State Capture Commission of Inquiry, where there were instances where the excuse that we are pursuing the empowerment of previously disadvantaged Black South Africans was used for a number of issues of wrongdoing, and also the issues that we've seen from the data matter that was reported on extensively over the weekend. Where does this leave the conversation around the framework and the legal framework around broad-based Black economic empowerment? Are the laws rigid enough, yet efficient enough to achieve the goals that we are seeking to achieve as a society, or do we need a complete rethink of some of these frameworks?
I think in terms of how we apply the law itself, that I think needs to change, because if you have a commitment, be it from government or the private sector, to say, okay, in terms of me becoming BEE compliant, there are 5 elements that I need to fulfill. You don't necessarily have to sell your ownership. You can focus on skills development. You can focus on employment equity. You can focus on supplier development, enterprise development, socio-economic development, and still be BEE compliant. The problem happens when people try and shortcut the rules that have been placed in terms of the legislation. If people apply BE with good faith, with an understanding and a commitment to transformation, then I'm confident that when these tenders go on to a committee and a decision needs to be made, then there would be no need for there to be sort of fronting issues where people lie about their black ownership in an attempt to get tender, or bribery and corruption, as we've seen in the Zondo Commission.
All right, thank you for your insights there, Muriel Mushariwa. Really